SJC-11482, Commonwealth versus Augustine.
Yes, good morning.
Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. We ask this court today to do either one of two things. First, to reverse the suppression order because the defendant failed to show that a search in the constitutional sense occurred, or second, to remand this case for an evidentiary hearing. Any other course of action would be inappropriate on the record before this court. This case, very simply, is about whether the defendant met his burden to show that a search in the constitutional sense occurred.
Can I ask you, I know that we don't have in the record the information that was actually furnished by the telephone company.
Yes.
But if you turn to attachment A of the order, it speaks about information that may be used to determine or assist in determining the physical location of the said telephone at the time of any of said calls.
Yes, Your Honor.
But not including any call or message content.
Yes.
Does the information that we don't have, that's not in the record, provide location information for each telephone call, or is it the registration information every 7 seconds?
It's not the registration every 7 seconds, Your Honor. It's the information for each telephone call.
So we don't have the equivalent of a GPS.
No, Your Honor, we don't.
Do you know, is there anything that indicates whether that information, the registration information, how it's kept, and whether that, when one sends a subpoena, whether one ever gets that?
No, Your Honor, there's certainly nothing before this record. As to that, by my understanding, and certainly I'm not an expert in telecommunications, but from my understanding, that's not something that's normally kept in the routine business practice of Sprint. It could be obtained in a case where there's a real-time monitoring of this type of information. So in a case where the police go to Sprint, and as the registration info is being sent to Sprint, where the police and Sprint are looking at this information together, it's my understanding that they could obtain the registration information that way. But certainly, there's nothing to suggest, and nothing that I've read, that through a 2703D order, there's any way after the fact to obtain this type of registration information.
But in the Fifth Circuit case, that order specifically requested information that was not limited to telephone calls.
Yes, it did, Your Honor.
So it does seem as if that information is potentially available under the Act, or at least potentially able to be requested.
Your Honor, I would say that there's a difference between the government requesting it and what any cell service provider actually would send. There's certainly nothing before this court on this record that would suggest that any registration info was sent. I would say to the extent that it's necessary to see if this is the type of information that's normally sent, it needs to be remanded for an evidentiary hearing. So the keeper of records from Sprint can get on the stand, and so we can ask him. And in the normal course of Sprint's business, is this type of information kept? Is it normally sent over? Unfortunately, I wish that I could provide more information to the court, but on this record, it simply isn't here.
Let me ask you this, though. I understand it's not in the record, but in the course of these proceedings below, did your office get it, and was whatever it is that Sprint sent obtained and shared with the defendant?
It was shared with the defendant, yes, Your Honor.
So it's really, so to get it, even though it's not part of the record, I understand that as a formal matter, but would there be an objection to request it, for us to request it?
Yes, Your Honor. And for that, yes, Your Honor, the Commonwealth would object to that. And for the reason I would turn the court to Commonwealth v. Berry, which is a 2002 case out of this court. And on page 805, footnote 6, this court says that it would be inappropriate for it to take judicial notice of the police report in that case, which was part of the clerk's file, because it was not either entered into evidence at the motion to suppress hearing or presented to the judge at the motion to suppress hearing.
We're not talking about taking judicial notice of anything. We're looking for evidence that you obtained and shared with the defendant.
Yes, Your Honor, while that's true, if the defendant wanted to make that part of his showing at the motion to suppress hearing, it was his burden to provide that information to the judge. where
Okay,
he-
so we're to send this back to the judge, directing the judge to have the parties put this in the record and then send it back to us?
No, Your Honor. I would say if you send it back to the judge, there should be an evidentiary hearing by which the defendant proves the claims that he's making here today, that
What if, we just want to know what was before you and the defendant? That's all we want to know.
I understand that, Your Honor. Unfortunately, it's not part of the record.
But it's easily made part of the record. Is there any dispute about what it is?
There's no dispute about what it is, Your Honor. But it is the defendant's burden at the motion to suppress stage. So if he wished to show that this type of record showed any sort of location or showed any sort of multiple
Do
locations,
you disagree that it does?
do we disagree that it shows a location?
Yes.
No, Your Honor, but we do say
I don't know what the problem is here.
it's the defendant's burden.
Okay.
Okay, but I guess the issue is, it shows the location with regard to where the telephone was when certain telephone calls were made and received. Is that correct?
Yes.
But you're saying it does not show the location every 7 seconds, which is what the registration information would reflect,
Yes.
even though the judge spoke of registration information.
Yes.
And nobody during the course of any of these hearings said, Judge, we're not talking here about registration information, we're talking only about the location where particular calls were made from?
I don't believe that registration information specifically was ever brought up in the motion, either of the motion hearings. I would say that the Commonwealth, the trial prosecutor during these motion hearings, was very specific about what the CSLI in this instance showed, where he said it shows a generalized location, not a type of location that was particularized to the
But that
extent.
doesn't tell you whether it's a call or whether it's a 7-second, right? Whether it's, right?
It doesn't, Your Honor, but I would say that where we said it's such a generalized location, I believe at one point specifically, I think it's page 32 or 33 of the record, he specifically says it would only show when the defendant made a call that the call went off a certain cell tower in that instance.
Now, I'm a little bit perplexed with regard to your judicial notice argument. I understand the theme, but pragmatically, are you saying that the law would differ if somebody seeks to find location information, say, from this courthouse, where according to amicus, we're surrounded by dozens of cell towers, as opposed to being, say, in Acton or in Westboro, where you may have fewer? Are we going to have to decide where, for each telephone call, whether or not it's a search? Is that what you're claiming?
No, Your Honor. My claim as to the judicial notice is that obviously this is a complex and evolving area of technology, both the law and technology. And I think it's important that the court understands what exactly this record is. And I would say that specifically, these type of records are hard to generalize, and it's hard to provide a sort of static definition of what they will or will not provide. So I think it's over-inclusive to adopt the defendant's position, which says that these records definitely reveal an enormous amount of private information, because there's nothing to indeed prove that they do regularly provide this type of information. It's simply to say to the court that this is an important issue in which evidence needs to be taken as to what these are and what locations are routinely revealed and what the cell phone companies routinely keep in their business practice as the type of records. It's simply to say we don't know enough about these records to make the findings that the defendant asked this court to make.
But don't we know enough to know that the detailed, the precision of the location is going to vary by where you are?
We do, yes, we do know that, yes.
And so, but of course, the judge who's approving this order isn't going to know where the person is going to go. They could be going throughout the state, and at different points in time, there's going to be different levels of precision with regard to the location information. So
Quite possibly, yes.
So what, I mean, let's assume you have your evidentiary hearing and learn everything,
Yes.
okay? And learn that the degree of detail at this courthouse is within 100 feet, and the degree of detail at a rural area in the western part of the state may be 1,000 feet or a quarter mile. What practical difference is it going to make for a judge reviewing that order to know what you're supposed to do with that?
I would say that the practical difference is this. It would show that First, in this case, that it is not indeed the same as GPS, which can reveal the location to 50 feet, which can reveal a much more specific location. And on this specific case, I think that's important. To answer the larger question, I think it's important because it changes the privacy interest that you could have. So let's say that it only reveals that you're in the state of Massachusetts, or let's say it only reveals that you're in Northampton as opposed to Boston. Why would a defendant have an expectation of privacy in that type of information, that he's in one town as opposed to another city?
Well, it doesn't, and you think that, well, I guess the judge did, but do you think that the amount of time, in other words, that the duration of the records matters? In other words,
Your Honor. Yes, Your Honor. I believe it does because it changes. A lot of the cases and the amicus and the defendant seem to say that long range, this type of information can reveal intimate private details, and that it provides it shows the patterns of a person's life. So it shows at 8:05 every day, I go to the same Dunkin' Donuts and Government Center. And that where you maybe wouldn't have an expectation of privacy in that one fact, you may have an expectation of privacy in the government knowing that invariably you'll be at that Dunkin' Donuts at 8:05. Where you only do it for 3 days or 14 days as opposed to 30 or 60, the pattern itself is lesser. So it's not as invariably true that you'll necessarily be at that Dunkin' Donuts at 8:05. So for that reason, the Commonwealth does assert that it does matter. However, to go back to Justice Gant's point about why an evidentiary hearing is necessary, I think it goes to our larger argument that this is a document that's held by a third party. And it would be helpful to both the court, and the Commonwealth certainly asserts that it would love to put evidence before the court as to what the specific policies of Sprint are and what the policies were in 2004 when the defendant's girlfriend entered into this contract. I think that too is necessary to determine whether the defendant did indeed have an expectation of privacy in these records. Now, historically, as the court knows, an individual doesn't have an expectation of privacy in business records that are held by a third party. And I would say that's important to the analysis because
We're not talking about an expectation of privacy in the records. We're talking about an expectation of privacy in the information.
Your Honor, I think it's both. The defendant is specifically contesting both the records and the information that the records reveal. However, if the defendant has no expectation of privacy in the records, then how could he have an expectation of privacy in the information that it does reveal?
Well, how far do you want to carry that? I mean, right now, I expect that your email provider probably has access to the content of all of your emails.
Yes, Your Honor.
Is it your view that it would be okay to subpoena Verizon or Google and say, give me all of your emails because they're in the possession of a third party and somebody who signs on with Verizon or Google should know that they have access to the content of all your emails?
No, Your Honor. And I would draw the distinction between the content of a communication and the fact that a communication was sent. The court has always recognized a distinction between that, going back to Ex parte Jackson, where they said that the outside of the envelope, the fact that mail was sent, is okay to look at because that's been voluntarily sent to a third party. But the inside of the envelope, you can't access the content, the inside of that
But the difference is that the post office can't look inside your envelope without opening the mail, which they're not allowed to do. But I gather that Google and Verizon have the capacity to look at the content of emails.
Yes, while they may have that, I would draw the distinction legally at the content as opposed to the fact
Well,
that it was
the
sent.
SCA draws that distinction, doesn't it?
Yes, Your Honor, it does.
So you think this is like looking at checks, canceled checks, third-party possession, and that's fine. We can get all your checks for the last 10 years and take a look to see where you've written them if you're still writing checks.
Yes, Your Honor. Yes, because it's a record that's held by a third party. I would say
Doesn't that,
You draw notice, any, as far as you're concerned, or the Commonwealth is concerned, it doesn't matter the context at all. The third-party doctrine uber alles, is that right? That as long as a private third party holds these records, whatever they may be and whatever the circumstances of providing them, you would say it's fair game because I voluntarily gave my information to that third party.
in this situation, yes. Yes, where there's where typically, and where we would expect to show at an evidentiary hearing, where the defendant has entered, or the defendant's girlfriend has entered into a contract by which Sprint says, we reserve all rights to track your location, and you don't have any expectation of privacy in that, then yes. Yes, where there is that type of evidence available, then yes. I see that my time is
So
running short.
one question as your time is expiring. So that you're saying that even if the information were as precise as GPS, and even if it were registration information reflecting your location every 7 seconds, it would still be available as long as you meet the requirements of the CSA?
That might present a different, I wish I could give you a yes or no answer to that. That would present a very different situation than here, because Massachusetts specifically has, through the Rousseau case, shown that you would have an expectation of privacy to not be so surveyed in that specific way. However, absent that showing, which hasn't been made here, yes, Your Honor, here there is no expectation because it hasn't been shown to be as precise, and because it's held as a third-party business record held by another individual. And to the extent that you wish to find that it is as precise or reveals such a precise location, the case needs to be remanded for an evidentiary hearing. And if there are no further questions, the Commonwealth will rest on its brief.
Thank you, counsel.
Thank you, Mr. Chief Justice, and may it please the Court. The record in this case and the law are both considerably less favorable to the Commonwealth than you've just heard.
Why isn't it important for us to understand what the Sprint policies were in 2004, what kind of information they collected and retained, how precise it was? Why isn't it necessary for us to understand that?
Well, you can understand that quite a bit, Your Honor, because at the time that the Commonwealth obtained these records, it had already, that is the CSLI records, it had already obtained the call logs for Mr. Augustine, and thus Trooper McCauley was able to assert in her affidavit that she knew for a fact that there was regular activity of incoming and outgoing calls on Mr. Augustine's phone. So the Commonwealth knew in advance that it would be getting abundant location information about Mr. Augustine.
How did they have the call log? What are call logs? What do you mean by that?
Just your first question, Justice Botsford, I'm not exactly sure how the Commonwealth had already obtained this information, but it had, by September 2004, a list of every call that Mr. Augustine had made or received for the relevant period. And Trooper Augustine asserted that to the magistrate who heard the 2703D order. The larger problem here, as some of the questions to my colleague pointed out, is that at the moment, this court right now is in the same position that the magistrate was in when the 2703D order was requested. And just like that magistrate and just like the Commonwealth, this court can't know exactly how precise the information will be.
But you want us to conclude that this is an invasion of privacy, all right?
That's
It's
correct.
very intrusive, the information that was obtained, very intrusive. But we don't know what information was obtained.
Well, what Your Honor does know is that what was obtained is the cell site location information at both the beginning and at the end of every call.
Every call.
Of
Okay,
every
let's
call.
assume that's it. That's all we
Right.
know. Is that different than every 7 seconds, a registration?
That is true, and that would put this case at a level of precision that's below GPS. But GPS level precision has never been the constitutional standard. In Caro and in Knotts, what the issue was a beeper that provided far less information than could possibly have been provided in this case.
So you say that the call logs are maybe they are the same thing as a pen register, but you get the same information, right? I assume that's what you mean. You get
it appears
incoming
that-
and outgoing calls.
It appears that that's
and
what the
what time
Commonwealth-
they were made, right? And what they were, the numbers.
Right.
So, which a pen register
Right.
right?
And I would point the court specifically to pages 13 and 195 of our supplemental record appendix. 13 is where Trooper McCauley talks about the regular activity on the phone. Page 195 at note 14 is where the Commonwealth, in its opposition to the motion to suppress, said that its troopers believed this information would show the defendant's location. It's not an accident that there wasn't an evidentiary hearing. It's because the parties were clear to Justice Sanders that location information was obtained.
So you agree that the only information obtained was the location at the time calls were made?
And at the conclusion of those calls, yes, Your Honor, yes.
Which means that the analysis we use for GPS would not be applicable because that speaks about continuous and extended location information.
Well, I agree to part of that, Justice Gantz. It certainly wasn't continuous. It was extended as this court, consistent with this court's law on warrants. A 14-day period is about the maximum that could be authorized under a sole wiretap warrant. It's 15 days. That's pretty much the extent of the length that is permitted.
Is that what this was?
This was an authorization for approximately 14 days, although it's also clear on the record that the Commonwealth got a longer period. And that sort of goes to the fundamental point, which is if courts do not look at the intrusion that this causes until after the information is obtained, there will be no protection. The Commonwealth's argument would be far better if it said that the evidentiary hearing should have taken place before they went to the magistrate, before the magistrate granted the 2703D order.
Well, there was a judicial order here. It's not that there was no showing of need and specificity.
Right, but that's true, Your Honor.
But to a judicial officer.
But the Commonwealth's present claim to this court is that the constitutionality of that order cannot be ascertained until after it issues.
Well, what we're trying to understand is what information actually was available. I mean, if you look at old technology, do I have a reasonable expectation of privacy when I go to somebody's home and use their phone, that the phone company and that the police might not know the location? I mean, the uniqueness here is you have a cell phone, so you're not quite sure. But
right,
old technology, I'm in someone's home, I make the call. Someone will probably know that I've made a call from a phone, from a home.
Well, there's two parts to that, Justice Cordy. One is the expectation of privacy issue, and I think your question is also getting to the third-party doctrine issue. So let me address both.
I'm really not getting to the third-party doctrine.
Okay. Well, with respect to the reasonable expectation of privacy, the standards that for years have been the Caro and Knotts cases. And in Caro, what the court said was that a beeper technology, which revealed nothing unless accompanied by contemporaneous physical surveillance, was sufficient to implicate a reasonable expectation of privacy if it could reveal the person's location in their home. And that can be done easily with the call information that was obtained in this case.
But isn't that true of the pen register too? I mean, if you go back in time when landlines were the rule, so presumably the landline is in your home, so every time you call or you get a call and it's answered, you know exactly where you are.
Right.
That is
the point I was trying to make.
Okay, well,
she did it better.
It's a good point, but the difference between this case and that example would be, say, in the Smith case. The pen register at issue there didn't, so far as the record reflects, reveal any times. It also doesn't tie a specific phone to a specific person. So to combine Justice Cordy's example with yours, Justice Botsford, when you know that a call was placed from a home phone, it really could have been anyone making the call.
Not true with cell phones?
It's far less true with cell phones. And the Commonwealth certainly believed and stated in this case.
But wasn't this cell phone wasn't she billed for this cell phone?
So someone else's cell phone, right?
That is true, but,
all right.
But the Trooper McCauley affidavit also asserted that the officers already knew that it was exclusively used by Mr. Augustine. This stuff is not in dispute, and that's why again, the decision whether to hold an evidentiary hearing not only did not come out of the blue, but it could not really help this court decide future cases. Because a rule that says the constitutionality of gathering location information happens after the information is required is not a rule that could protect anyone's location information from gathering by the Commonwealth. The other thing that really separates this case from some of the other cases is the nature of the supposed acquisition and gathering of business records. This goes to the third-party doctrine.
Okay. Before you get there,
Certainly.
is it your position that there is no difference constitutionally between the registration continuous location information versus the episodic location information that arises when you only identify where a call is made from?
I believe the answer is going to be the same, that both are searches that require a warrant. But it's certainly a stronger argument when it's GPS data. I don't dispute that at all. But what is clear when it is CSLI information, and what the Commonwealth has not disputed, is that that is sufficient to reveal intimate details of someone's life. I'm sorry,
You finish.
if the Commonwealth collects information about 14 days and nights, then it knows, based on just the CSLI, where they are sleeping, when they are sleeping somewhere else.
How do they know that if there's no calls being made?
Well, they knew in this case there was regular activity on the phone.
24 hours?
When you use the word, the term CSLI, you are referring to the call information, not the registration information. That's how you use CSLI.
Well, it's
when
any
you're talking about it right now.
It's any information, including registration or it could be any information at any time about the cell site and face of that cell site that communicated with a phone. In the attachment to the 2703D order in this case could have obtained any of the, either registration or incoming calls. It was tied to the time of incoming calls, but if there was registration information happening at that time, it would have been turned over.
What if Sprint doesn't preserve that information? Simply not available. They don't track it.
Well, one of the peculiarities of the Commonwealth's argument is that it would turn the Article 14 question here into a question about what cell phone companies choose to deduce.
Well, not really. I mean, we could say that people have a reasonable expectation of privacy, that their locations won't be monitored every 7 seconds, but they don't have a reasonable expectation of privacy that when they make a phone call, there will be a record of the place from which the phone call is made, and maybe we don't think that's enough.
Well, you could say that, and in a moment, I'll say that why I don't think that would be good, but I would just point out there's actually a difference between what you just said, Justice Cordy, and what the Commonwealth has said. It would be fine for the court to say, here's where we draw the line, but it should not depend on the business practice of a cell phone company. Sprint could decide tomorrow that it's going to collect and record the triangulated location information and registration information of everyone in this courtroom. It could decide that.
If the police sought to obtain that information, they would have to get a warrant, let's say, if we agreed with you. If they only sought to obtain the information of the location of a phone at the time it made certain calls, maybe not, maybe just an order.
Well, the maybe there is important, because if there is any chance that a volume of call activity could be sufficient enough to trigger a protected reasonable expectation of privacy under either the Fourth Amendment or Article 14, it would be an unworkable doctrine to say that we ascertain that maybe only after the Commonwealth.
I mean, the government requests, they're seeking by means of either a warrant or an order, very specific information. If they request all of the information with respect to the location, maybe that's a problem. If they request locations only when the phone is used, maybe that's different. So doesn't it depend on the nature of the request?
Yes, Your Honor, but then it would also depend on the time of the request. So at the time of the request, maybe the Commonwealth could be required. I don't think this would be ideal, but the Commonwealth could be required to say, we know for a fact, we looked at the call logs, we looked at the text messages logs, and unlike most Americans who communicate using their phones at least 50 times a day, this person didn't. This person we know made 2 calls, and that would be information to present to the court. And then the Commonwealth could also say, and here, by the way, court reviewing the 2703D order, here's a map of the cell sites at the time. And here we have ruled out the possibility that they disclose a particular information. That wouldn't be great from our perspective, but at least it would be workable. It would be far different from what the Commonwealth is saying here, which is that they do no investigation, that in this case they didn't disclose the location of the cell sites until after the suppression hearings. And then, after it gets all the information it wanted, after any Article 14 or Fourth Amendment rights are either violated or they're not, then we decide whether there was a search. And that's why we use this example in our brief of how we don't determine whether the search of a bag is unconstitutional by looking at what was found in the bag. Courts, there's no example that I know of that would say that the Commonwealth gets the information first and then afterwards there's a determination based on evidence that couldn't have been available when the government conduct occurred about whether
You're talking about the frequency, I mean, for example.
Exactly.
Like if you're in Boston and the cell towers are all over the place
Right.
versus Montana.
Exactly. So in this case, it's a little bit harder for the Commonwealth than that because they knew that all of the relevant events occurred in and around big cities. But in theory, even if the Commonwealth knows in advance where the cell sites are, it doesn't know, it cannot know in advance which of those cell sites and which faces of those cell sites communicated with the phone.
Can I just ask you this? Assume that, yes, a warrant was required, and the warrant wasn't obtained, but here we are now in 2013, and can the Commonwealth, assuming Sprint still had the records, could the Commonwealth now seek a warrant, get probable cause? It's now 9 years later, they know a lot more about this case, and get the same thing?
I see that my time is about to expire. With the Chief Justice's permission, I'll answer your question.
You have my permission, please.
Thank you, sir.
You might not want it, but that's all right.
I was going to just bolt for the door, but now I have to answer.
Okay.
There would be a very difficult, inevitable discovery taint kind of problem with showing probable cause. But I think in theory, if the Commonwealth had somehow had amnesia and because of that amnesia was looking at this case fresh in 2013, yes, I think the type of answer you're describing, Justice Botsford, could work. But
They could certainly provide the same affidavit that they provided to get this order. That would not be tainted.
That's true, but it would have to be a different affidavit, Justice Gantz, because that affidavit was pretty clearly not seeking to establish probable cause. It just said it was seeking to rule in or possibly exclude Mr. Augustine as a suspect, which is a statement that would be equally applicable to everyone in this room.
It's seeking evidence with respect to whether he was present at the scene of the crime, right? They had reason to believe that he was, and this is seeking evidence to that effect. But let me ask this way. Let's assume that the Commonwealth was seeking just that. On August 6, 2000 and something, a crime has been committed. We have reason to believe the defendant was there with a cell phone, or this person was there with a cell phone. We're looking for his location at this time. One shot. This is not we want to know where he's been for the last 3 months. One day, one night. Where was he? What do you think? Warrant necessary or just compliance with the federal law?
Two things. First of all, yes, we would say that a warrant is necessary because even one shot can determine whether the person was at home, sleeping somewhere else, at a doctor's office, and not. That's, of course, a harder question than this case, which has this lengthy period of information. But the second point I would make, Your Honor, is that it shows why a warrant is necessary. Because when a warrant and its minimization requirements and its return requirements are not used, the Commonwealth doesn't just request the one shot. It was interested, in this case, it said, in 2 days, but it requested 14 and got many more. There was no check on what the Commonwealth would get, could get, or did get. And that is because without the protections of the warrant requirement in advance, when everyone is in the dark about what exactly will be shown, there is essentially no protection for the privacy of the many people who are subject to these requests.
Thank you, counsel.
Thank you.